Good morning, everyone. Thank you so much for joining me on my channel. My name is Primrose, and if it's your first time here, you are welcome. And if you're a returning Sabi, thank you so much for the continued support. Guys, today we got to see convicted RPist and murderer Thabo back in court. Thabo claims his belongings were unfairly taken when he was rearrested in Tanzania. He filed an application at the Pretoria High Court demanding access to his laptop. And guys, a lot of people were like, could this be his way of trying to prepare for his next prison break? So guys, I was like, honestly speaking, guys, feelings aside and everything, this guy Thabo is very smart and very well articulated, to tell you the truth. The guy is well spoken. Like many lawyers just wish they were just half of what he is in terms of sustaining a case. Because we've seen some of them, the lawyers, guys, in the stands here. And honestly, what they do for me is totally nothing as compared to what Thabo has just showed us. And I'm asking myself, why can't they let this guy represent himself? Imagine a guy that managed to convince a whole doctor to fall in love with him and did all the things that they did, guys. And even escaped and even managed to skip the country and go as far as Tanzania. Guys, honestly, but anyway, like I said, guys, feelings aside, I was just trying to tap into this guy. Another thing I wanted to really understand, that isn't it within his rights to challenge the system for the resources to prepare for this case? Guys, criminals also have got rights. Yeah, I'm not trying to speak for Thabo. It's just that I feel like sometimes they should just give it a chance, a try and see. Isn't it that they can make that laptop to not have access to so many things? They can monitor it, just like what he said. But anyway, guys, go ahead and check out this video. Please let me know in the comment section what your thoughts are. Remember to give this video a like, a share, and consider subscribing.
In court, that the device can be removed from me. If I infringe on any of those, it can also be removed from me. But at this current stage, Your Honor, I see no reason why I cannot put my own application and argue my own application as best as I can. And I feel that at this current stage, I am treated unfairly because I approach an application and already I am faced with a circumstance where I am not feeling that I am given an opportunity to hear, where I can argue and put facts before. And if the court, because I was not saying that this is the only resource that would make it accessible to court, but it should be able that when a person does not have financial muscle or financial resources, they should be able to access the court and argue whatever they wish for litigation. It's a constitutional right. And if that access is moved digitally, then the prison has to move digitally. It's proven by what I've brought before the court that other prisons around the world have taken the same process, because everything is turning digital and print is fading out. There is no longer as many newspapers as there used to be, and there will probably won't be for very long. So I am asking the court to take consideration that access to digital resources in prison is not a violation of human rights. It's not a slap in justice's face. It's not a disrespect to this court or anyone. It's just a humble plea that I request access to court. And if that is denied, then it means I do not have access to justice. It means I don't have access to court. Because if the court says that I should only access books, you're still limiting me, because it was proven in Denmark that access and meaningful access are two different things. I do not have meaningful access because I depend on someone else. It is also stated in the urgency application where the respondents questioned why we took so long to file. My assisting attorney to do correspondence, her laptop and cell phone was stolen at the prison. She was not able to file. There's a case number in everything. The correctional services are fully aware of this fact. But what I'm trying to say is that I am now dependent on another person to file an application. Even getting to this court, I had to physically try and request numerous assistance to get just the requisition to the respondent. And I am saying that this should not be the case. I should not be struggling to access this court. I should not have to come to this court to ask for a basic right. because it is a guarantee through the Constitution that we are all equal. I do not feel equal at this stage, with respect, Your Honor, that I was bringing an application and I felt that you were attacking me without giving me an opportunity. But I apologize if I offended you. But the bottom line is that I really just want access. It does not matter what form or what measures the respondents can bring, as long as it's access. They know very well, outside the allegations that have been brought, that I face currently, and the unfounded allegations of charges, I have, for a numerous time, have not infringed on any of the acts or regulations of correctional services. I have not been in any way difficult to the correctional services. I've complied with every rule that they have put before me. And there is no evidence that they can bring except allegations that I have not complied. And all I'm asking you, Your Honor, is that So, Your Honor, before I respond, I actually, on my side, I argue that it's unfair, Your Honor, that to even accept the papers, Your Honor.
That's why I'm asking you if you want to respond to it. I haven't accepted them.
Okay, I'd like.
That's what I said to counsel. I'm not accepting them. I want to see what they say.
Okay.
So they are bringing in. I assume you will want to respond to them.
Yes.
That's what I'm asking.
Yeah, I can
How
respond.
long do you need
To respond to their,
to this application for the further evidence?
as in if the court accepts it.
Yes. Well, in general, because the court must decide whether to accept it, and I assume that you would want to file a response to say why it shouldn't be accepted.
Yeah, I would. I think I'm prepared, Your Honor. It's fine.
So
There's nothing I can
you
do.
will just argue. Just remember, Mr. Bester, I can't hear your evidence if it's not on affidavit. This isn't a trial.
I understand.
So you will have to stick to your founding affidavit and the replying affidavit you've already filed.
Yeah, Your Honor, but if I have to do that, Your Honor, it means that I would have to write in hand and submit in hand.
Then that's what you must do. I'm giving you that opportunity.
Okay, how long will I get to do that?
As much time as you need. I can simply remove the matter from the roll and you can set it down when you're ready.
Okay. No, if you can give me an hour.
An hour.
Or do you want to give me a long time? I don't know.
As much. Tell me how long you need, Mr. Bester.
2 hours is fine.
I think rather what we would do is stand that down for Thursday morning. That will give you a day to file a response, and you can file by tomorrow morning at 10, and you can file by a reply if you need to by tomorrow at 5. Just understand, you must stick to what you've already said in your founding and replying affidavit. I'm not allowing submissions outside of that. You've made a lot of submissions now outside of that, and I've allowed it, but it's not admissible in front of me. It has to be under oath. You've made a lot of allegations about countries like Belgium and Sweden and the USA and Australia allowing devices for this. That is not admissible evidence. If it's not an affidavit, I cannot accept it and I won't accept it. Those are the rules of this court. That's why I asked you. You want an hour or two, I'll give you an hour or two.
Okay.
But if you want longer, then what happens is this is the procedure. I remove the matter, and when you're ready, even if it's in a week or 2 weeks, you can set the matter down for hearing again. It doesn't mean it's urgent. That judge will decide. But I will give you the opportunity to respond. That is your right.
Okay. Is the court saying you're accepting the application?
No. I'm saying I'm giving you the opportunity to file an affidavit to say why it shouldn't be accepted.
Oh.
And to respond to it in the event that that court does accept it.
I understand, Your Honor.
You understand? If you don't want that opportunity, that's fine. Then I will make a decision myself on whether to accept this new evidence. But then, as I say, Mr. Bester, and this is why I'm repeating this for the third time, you are bound to your founding affidavit and your replying affidavit. That is the evidence you give this court under oath. I don't accept evidence outside. That's why I'm asking.
It's fine, Your Honor. We can
What do
proceed.
you need?
We can proceed.
We want to proceed.
Lady, I just wanted to say that if Mr. Bester is worried that his time for filing a replying affidavit in the main application has run out and postponing this matter to Thursday will put him in more trouble. I can just take instructions from my client, because I think in any event, it was going to be a sensible thing that his time for filing the replying affidavit should start running whenever the order is given in this matter. I would presume that would be a sensible thing. So if he was going to have 10 days to file it, ordinarily he would still have that 10 days. I can't see that there will be prejudice to my client. Yes. So because I'm just thinking on the question of practicality, and also accepting that, on the part of my client, the court is only getting the application today. So if Mr. Bester has it, he can consider it, the court can consider it properly, and then in the next 2 days, literally, we can all be back here and know that all the housekeeping issues and all the matters are dealt with properly.
Mr. Bester, do you understand?
Yes, Your Honor.
So, Mr. Masibuko says your main application won't be in jeopardy. You will only be, the time within which you have to file your reply affidavit on the main application will only start running from the day this court gives an order. So you won't have to worry about the complication.
Okay. No, it's fine, Your Honor. If we are given till 2 o'clock, 3 o'clock, I think by then I would also even draft my own affidavit. If it's today, if it's on Thursday, it's fine. I'll also put my own affidavit to respond.
Mr. Bester, I want you to think about the time you need, because I don't want an argument later that you weren't afforded a proper opportunity.
Yeah, no, I'm fine with 2 hours, Your Honor.
All right. Then this matter will stand on.
Thank you. Lady K.